Your Honour, I appear for the applicant, Sunny Barjar, and will be making 3 submissions. The applicant's first submission is that the evidence of the backpack and its contents are inadmissible as they lack relevance in supporting a fact and issue of section 233 of the Criminal Code. The test of relevance, as outlined in Goldsmiths, is that evidence is relevant only where it could rationally affect the assessment of the probability of the existence of a fact and issue. The relevant fact and issue here is whether the applicant was in possession of the unlawful gaming equipment. Possession, as defined in section 1 of the Criminal Code, requires the applicant to have had control over this gaming equipment. The equipment was found in the car of the applicant's de facto wife. This does not lend support to the finding that the applicant was wielding control over the gaming equipment. Considering the comments made by the applicant, as required in the case of Fung, that you would be low enough to take a man's 2-up gear, is made in the third person and suggests that the equipment could have been the possession of any man or, for that matter, woman. However, the comments do suggest that the applicant had knowledge of the contents of the bag. But as in the case of Solway, knowledge is insufficient to prove possession and certainly cannot be said to rationally affect the assessment of the probability of the fact and issue. The backpack and its contents are not relevant to the facts and issue here, and the court should find that the evidence is inadmissible. Counsel now moves to the second and third submission, which should only be considered by the court where the first submission is rejected. The applicant's second submission is that the search of the applicant's de facto wife's car was unlawful. A vehicle search without a warrant is unlawful unless section 160 or section 31 of the PPRA applies. Here, the relevant factor is section 31. Section 31 may not be complied with on 2 accounts. Firstly, the constable could not have had a reasonable suspicion that the applicant was wearing a prohibited item after the applicant informed him of the fact that it was not the suspected badge. However, the more compelling reason is that the constable acted beyond the power to search a vehicle without a warrant as granted in section 31. In Keene, it was found that the officer must detain the occupant of a vehicle prior to conducting a search of the vehicle. Here, this did not happen, as neither the applicant nor the other occupant of the vehicle were physically detained or restrained as per the case of P and N. For this reason, the search of the vehicle without a warrant was not within the powers granted under section 31 of the PPRA, and therefore the search was unlawful. The third submission is that the judge's discretion to exclude evidence on public policy grounds should be exercised to exclude the evidence which resulted from the unlawful search. In exercising this discretion, the court must weigh the competing public interests of bringing a conviction to a wrongdoer and the effect of curial approval being given to unlawful conduct of those tasked to uphold the law. In weighing these interests, the case of Bunning and Visak have identified a number of factors to be considered. The first factor is whether the unlawful conduct was a mistake or a deliberate disregard for the law. Here it is likely that the constable was ignorant of the requirements of the law. He was a junior officer and no evidence suggests that he deliberately disregarded the law. In Keene, it was established that ignorance of the law may only be mistake where its construction had not yet been judicially considered. And this is not the case here. Neither the case of Keene and many other cases have considered the construction of section 31, nor is it the case that the officer was mistaken to a material fact, and hence mistake on the behalf of the officer may be ruled out. Applying Toon, this means that the constable acted in reckless disregard of the law, with P&N noting that a failure of an officer not to know the restraints placed on their powers is a serious matter which leads great weight to the exercise of the judge's discretion. The second factor relates to the cogency of the evidence, but as the evidence was neither obtained by mistake nor perishable, this factor lacks relevance here. The third factor is the ease of complying with the law. The applicant had previously breached Section 10C of the Summary Offences Act and hence the constable had the right to detain the applicant and the driver of the vehicle. This could have been done with ease in the centre of Brisbane, and as stated in Toon, the constable could have acted lawfully with ease, and the court should be reluctant to settle for such a lax approach to compliance with the legislative requirements. And hence, this lends weight to the exercise of the judge's discretion. The fourth and fifth factor will be considered concurrently in the comparison between the nature of the offence and the unlawful conduct. As noted in Bunning, the more serious the offence, the more likely that the public interest requires the admission of the evidence. In P&N, the officer failed to act in accordance with the limits placed on their power to search a vehicle without a warrant, as outlined in section 31 of the PPRA. However, the offence which this was to be weighed against was the possession of a large quantity of dangerous and unlawful drugs. The court found that as the police had been systematically failing to abide by the limitations placed on their power under section 31 of the PPRA, the nature of the unlawful conduct warranted weight be added to the exercise of the judge's discretion. Here, the same section of the PPRA has not been complied with, but the offence of the applicant is of a significantly less serious nature, and it is only logical that this consideration add weight to the exercise of the judge's discretion. All factors support the third submission, that discretion of the judge to exclude the evidence on public policy grounds should be exercised to exclude the evidence which resulted from the unlawful search. Your Honour, this concludes the applicant's submissions. Thank you for your time.